Article 32 of the JV agreement or not. And the second submission is that subject to the BID whether the direction of the government of Zambia is justifiable. And then in the next 7 minutes, my co-agent will addressing the last submission. May I move on the first submission? To deal with the first submission, we have two elements. The first element is that according to the Article 1 of the Charter of the JV, Article 1 defines that Article 32 of the JV agreement, Moreover did not have the right to voting to pass any resolution that may adversely affect the economic benefits of Anderson in the JV. In the business dictionary, benefits mean that the benefit that quantifiable in terms of money such as revenue, net cash flow, or net income. Following this, Moreover must consider the benefit of Anderson. In fact, Moreover deliberately exercised the act of voting to pass the resolution to decreasing the travel fare that resulted in the loss of Anderson by 20%. And the second argument is that Moreover's act affected the normal business of the JV, not because of the lowering travel fares of Moreover. Not only Anderson but also the JV had to suffer the serious loss. Indeed, the net income of the JV decreased by 40%, while the expenditures such as the cost to maintaining the highway or the pay for the employees were not allowed. Thus, the JV was in a hard situation and could not run its business normally. As a result, Moreover obviously infringed the Article 32 of the JV agreement, which to pass a resolution of decreasing the travel fares.
Also, you say that the contractual agreements between parties may prevail the constitution document such as the charter of the JV.
Please.
Would you say that the GBA has a higher legal validity than the charter of the company?
Yes, because the JV is the bigger because the company is belong to the JV, so the charter of the JV is have a more legal effect than the rules of the company. And may I move on the second submission that subject to the BID whether the direction of the government of Zambia is justifiable. To deal with the consequence of the financial crisis, the government of Zambia made many directions to relieve the bad effects of the crisis, such as issuing the Decree 60/2007 and directing the representative representing Moreover's interest in the JV to lower down the travel fares from $150 to $75. The direction of government of Zambia do not have any accordance with the standard of treatment provided in the Article 2.2 of the BIT. Under the Article 2.2 of the BIT, each contracting party is at all times accorded fair and equitable treatment and not impaired by any unreasonable or discriminatory measures. And the government's measures are unreasonable because the direction taken by the government of Zambia are not the only way to relieve the bad effect of the crisis. In fact, there are other measures to balance between the Anderson's profit and the country's profit, such as negotiation of the reasonable price before issuing the directions. Furthermore, making negotiation and discussion can show the fair and equitable treatment of the government of Zambia to Anderson. In fact, there is no negotiation and representative and discussion between Anderson and the government of Zambia before issuing those directions.
Counsel, are you aware of any precedents for the standard treatment under Article 12?
Yeah. May I have 3 minutes? According to Article 12 order provisions in BIT, notwithstanding any provisions of.
Do you have any precedents, like any other countries have dealt with this situation before?
Sorry, this is not what we have.
Okay.
And may I move on to sum up the first 2 submissions, we state that Moldova has infringed the Article 32 that adversely affect the normal business of the JV in general and Anderson in particular, and under the rules of BIT, the direction of government of Zambia is unjustifiable. And then in the next 7 minutes, my colleague Mr. Nguyễn Minh will present the last submission.
Good morning, administrators. My name is Nguyễn Minh. In the next 7 minutes, I will respond to the last submission. The last submission consists of 2 arguments. The first argument is requiring the Moldova Act of voting to lower the table fares based on requirements that needs for compensation liability to arise. And the second condition, the second argument is that the loss that Anderson had to sustain is entirely caused by the act of Moldova. To the first argument, the compensation liability arises as the legal case meets the requirements. Illegal act consequence in reality, causality in the illegal act and its consequence. And the last default, approved by my co-agents, the act of voting of Moldova resulted the loss of JVs and Moldova. And then it infringes Article 32 of the JV agreement. Furthermore, the consequence of the releasing table fares must be foreseen by Moldova. But in fact, Moldova still exercised the act of voting to pass a resolution to the judge to decree the table fare. This means that Moldova does not consider the benefits of Anderson, and thus Moldova obviously had the fault. To reason deductive, Moldova acts in mixed on requirements that needs for compensation liability to arise. To the second argument that the loss that Anderson had to sustain entirely caused by the act of Moldova. The highway soon grew to be an important way in the domestic traffic. Therefore, despite the impact of financial crisis, a number of people using highway would not be diminished significantly. To reason deductive, although there are negative effects from prices that may lower the benefits of Anderson, the loss that Anderson would have to suffer is not as much as resulting from the act of Moldova. And this is my prayer for relief. In light of poor submissions, Anderson respectful request HCMULAW aspirations to declare that Moreover, are voting to pass the travel fares in relation to speedy highway tax is unjustifiable. As a result, the resolution about lowering the travel fares in relation to speedy highway is void, and the travel fares must be fixed at the rate of $150 until 2017. And as last, the claimant should be awarded an injunction to be compensated the entire loss from November, the entire loss in the period from November 2008 to the day arbitral shall be the final award.
What are the losses you are talking about? Is this the interest loss or the revenue loss?
The loss consists of 20%. The loss of Moreover of Anderson is that the dividend of Anderson fall for 20%, and the second is that when the travel fare decrease from the period when the travel fare decrease it costs many it must spend many fees such as employment salaries, maintaining costs for the SSB, Speedy Highways Project.
Respondent in this case. It's my honor today to appear in front of the Legitimate Arbitration Center to be today's coalition dispute. I will speak in the first 7 minutes with my submission, which regarding to whether the reaching of Moreover cooperation with Anderson in the joint venture agreement will transform into the reaching of Zambia government with the trusted country under the BIT. And then my coalition will speak in the 7 minutes next in regarding to the submission that whether the violation of the Moreover of the Zambia government is justifiable and the liability of the Zambia government. And if I may, I will begin to my presentation. In my first submission, I will include two arguments. The first is whether the Moreover Corporation must all time obey the direction of the Zambia government, and the second is whether the violation of the joint venture agreement of the Moreover Corporation with the Anderson Group will transform into the violation with the Zambia with the trusted country in BIT. And first, regarding to the purpose and the mission of Moreover in the chapter of Moreover, this company must obey the direction of the Zambia government. And regarding to the in 2003 investment of the Zambia government, this company must accomplish the economic goal set by the government and do its best ability all time for the people of Zambia, so that in the financial crisis in 2007, they is treated to the essential interests of the people of Zambia. Therefore, when there is a direction from the Zambia government, the Moldova Corporation must obey the direction. And the second argument, that is,
you mean that the jurisdiction must obey the law of the country, no matter how reasonable it can be.
Because this country, as I know that the Zambia countries is just developing country. Therefore, the Moldova Corporation is the vehicle for the countries. So that I think the law must to set down a track for the Moldova Corporation to follow the direction of the Zambia government to follow the economic policy of the country.
Right, but in 2002, your country has signed a number of BIT with a number of other countries.
Yeah.
We want to protect the foreign investment. So, how do you respond to Claimant's argument about Article 12 of the BIT with just now?
Yes, I will refer to the next argument.
Yeah.
We admit that the predominance of the Moldova Corporation in the voting rights, because Moldova Corporation own at least 50% of total charter in the G1 GDs, and the condition to pass the resolution is just at least 51%, so that it's easy for the Moldova Corporation to pass the resolution. But in the joint venture agreement, the Article 32, that the Moldova Corporation agreed to not vote for the favor that it adversely affects to the benefit of Anderson. And in fact, that the Anderson Group have to suffer for the loss that is the dividend, that is 20% in this 2008. And therefore, I can conclude that the resolution is void. And the Moldova Corporation breached the Anderson in the joint venture agreement with Anderson. But according to Article 4 in ILC, any conduct of the organs which have the status international law must consider as the conduct of the state. Therefore, in this case, we consider on time Moldova Corporation has to obey the direction of the Zambia government. Therefore, the breach of the joint venture agreement is actually the breach of the Zambia government with the Anderson Group. And also in the BIT, in Article 2, there's elevate all the contractual obligation from the transform into the breach of BIT. So we can conclude that the violation of the Moldova Corporation with the Anderson Group is actually the violation of the Zambia government with the trusted country. This is all my reason. That means the liability of the Zambia government will be represented for my cohesion. Will explain.
Whether the direction of Zambia government asking Moldova to narrow the travel fares in 2007 is justifiable, and so government of Zambia is not liable to the loss of Anderson Group. There are two agreements with this submission. The first agreement relating to financial crisis in 2007 is necessity, and the second agreement relating to whether Zambia must pay compensation for Anderson Group or not. Firstly, I would like to begin my first argument relating to financial crisis in necessity or not. Firstly, I would like to mention about the loss of a country that Zambia must suffer in a financial crisis 2007. There are so many loss. Second, GDP decreased 15%. The second, unemployment rate raised every day, and the demanding of reducing fare and tax doesn't seriously impair to the essential interest of substance. They are just serious impair to the interest of a company as the Anderson Group. So based on Article 25 of ILC, they relate that any state can take a necessity to review the wrongful act when the measure is the only way to take down the essential interest, and the second condition is this measure doesn't serious impact to the other state in this situation that they understand. So we can conclude that the direction of Zanzibar to Moldova in this state is unjustifiable because of the state of necessity.
Right. Are you aware of any precedents about any other country has successfully exercised exemption under the BIT? I mean, the necessity situation?
In this case, Argentina has a financial crisis like Saman, and they invoke the state of necessity to protect their essential interest.
What constitutes the necessity situation? So there are two factors to constitute a necessity situation. First is the measure is the only way, and that measure cannot be fair. Yeah.
Whether the farmers have compensation for Anderson Group, Azamba and Toscan agree in the BIT that any party can take any measure from maintain the public order, and public order may apply when there is genuine and serious and sufficient threat, and is must relating to fundamental interest of a society. And this is a former NPM law in international law, which relates the responsibility, liability, and also the duty of the state on the that state cause the damage to the investor, like this situation. The NPM laws express that there are three conditions to apply NPM law. The first condition is necessary form. In this case, the measure is necessary for the public order in this situation. And the second, permissible objective around public order. And the last one, the scope of this law is genuine and sufficient threat. Based on NBM laws, we can conclude that the Zamba in this situation can be protected by NBM law because they apply for public order. So in conclusion,
one more question. Is there any rules that require the country to exercise any good faith negotiation or precaution warning to foreign investors before they can apply the necessity measures to this?
Yeah, and that they on unimplied covenant of good faith and fair dealing in international law, and before they apply necessity, they must pursuant to good faith and fair dealing in international law.
Do you think that the country has fulfilled those obligations?
Yes, but in this case, defendant crisis is urgent, very urgent, and it's cost so many months to the Jamba. So we must apply the necessity instead of apply any situation. Jamba doesn't have to be liable for the loss of unexample in this situation. That's all our application.
Do you have any prayer for you?
Yeah. We method in our submission about direction of the Jamba in this situation in 2024.